Proponents use opinion polls as part of a major strategy to convince their opponents and the voting public that most Americans now favor the legalization of physician-assisted suicide and mercy killing, and that legalization of these practices is inevitable. Now, this can be a very effective strategy, for if the American public comes to believe that legalizing physician-assisted suicide and mercy killing is desired by most Americans and will inevitably be realized, that same public will tend to view opponents of such practices very negatively. As representing a minority viewpoint, opponents of legalized physician-assisted suicide and mercy killing can be seen as seeking to impose their own morality on their fellow citizens. And we saw that going on last night. And if such opponents invoke their Christian convictions, they can be seen as pushing a particular religious viewpoint not shared by Americans generally, a viewpoint that is inappropriate as well as irrelevant as a guide to what public policy ought to be, and we saw that last night also. Understandably, Christians themselves are tempted by poll data and media use of them to think that they represent a minority opinion, an opinion that cannot or perhaps should not prevail as the law of the land in a pluralistic, democratic country. But Christian beliefs are relevant and appropriate to the shaping of American public policy. Indeed, they are needed as never before, particularly, though not exclusively, on such issues as physician-assisted suicide and mercy killing. And this is true for at least two reasons. One, Christianity at its very core affirms the natural human proclivities and inhibitions that actualize the moral bonds, the human relations logically and functionally necessary for the existence of individuals and communities. The Ten Commandments. Two, the whole way of thinking that currently challenges existing laws against assisted suicide and euthanasia denies what Christianity affirms. This perspective affirms instead that individuals naturally pursue egoistic desires at odds with what makes communities possible and sustainable, and affirms, moreover, that the pursuit of such egoistic desires is a moral value, a basis for claiming certain individual rights, such as autonomy. And we saw that the other night. This is a streamlined version of Mill, the utilitarian. It is fairly pervasive in the bioethics literature and American courts. It is at once an attack against the shared morality sustaining our institutions, indeed our communities, and against the Christian beliefs that instruct and motivate individuals and groups to embody this shared morality. In Christian parlance, this shared morality is the law written on the heart. As the collapse of communism amply demonstrated, no community can long exist if this moral law is flaunted and those who honor it are suppressed. This is one Christian conviction absolutely essential to public policy. in any community. Other religions do share it. That laws and governments must share it as well is the central conclusion of this analysis, the present analysis. Now, the analysis will proceed in three segments. First, it begins with a brief assessment of the shift in public opinion toward a more permissive attitude toward physician-assisted suicide. Then, secondly, it proceeds to analyze the dominant set of concepts fueling this shift, largely found in a streamlined version of Mill. It concludes by arguing that Christianity is part of a long-standing consensus against assisted suicide and has a definite positive role to play in shaping law in this and other areas. And since laws permitting assisted suicide are destructive of the moral bonds of community and the shared morality that actualizes them, Christians have a moral responsibility to do what is in their power to maintain and strengthen the long-standing consensus underlying current laws prohibiting assisted suicide. To carry out this responsibility is not a power play or a contrived strategy. It is rather the effort of Christians to practice love of one's neighbor and to protect the very basis of neighborliness. So first, the shift toward more permissive attitudes toward physician-assisted suicide. What do we know about public opinion? To begin then, what do we know about American public opinion regarding physician-assisted suicide? If those who use polls strategically to push for legalizing assisted suicide are correct, a clear majority of Americans side with these strategists. Examples of this strategic use of polls abound. Let one suffice for this presentation. 2 days before the vote on Washington State's referendum, Initiative 119, which, if passed, would have legalized physician-assisted suicide and mercy killing, the Boston Sunday Globe published a major article under the headline in bold print, "Poll, Americans favor mercy killing." According to this poll, 64% of the American public favors physician-assisted suicide and euthanasia, and 61% would vote for Initiative 119 if it were on the ballot in their state. But one should be skeptical of these poll data. Whereas the polls showed 61% in favor of Initiative 119 in the state of Washington, only 46% of Washington State's voters marked their secret ballots that way. The disparity between the public opinion polls and the results gleaned by secret ballots in California was even greater 1 year later in 1992, as voters there defeated a referendum to legalize physician-assisted suicide by the same 54 to 46% margin. By the way, that was seen as one of the largest disparities between pre-voting polling and the actual vote. That's interesting. Yet these polls are taken at face value, even by people who should know better. The Globe confronted John J. Paris, a Jesuit teaching medical ethics at Boston College, with their poll results indicating that 71% of all Catholics would vote for the Washington Initiative. Paris gave them the quote they wanted, the one the Globe wanted. Quote, "It's quite clear 2/3 of the Catholics don't believe what the bishops are teaching." End of quote. No scholar has any basis for such a generalization from one poll, and I could go into how that poll was conducted and what questions were asked. There were two ways to be in favor of euthanasia, one way to be against it. But Paris, alas, is not alone in treating poll results as hard data. Don't do it. It seems that our friend Pellegrino had better Jesuit training than is currently available at Boston College, at least in one case. Even though polls tend to exaggerate considerably the support that exists for legalizing physician-assisted suicide and euthanasia, the change in attitudes toward these practices is real. In 1994, the people of Oregon did approve a referendum legalizing physician-assisted suicide, as you know, albeit by a slim 51% margin. Sometimes I hear 52%, sometimes I hear 51%. Presently, the referendum, as you already heard, is being reviewed by the courts, so it has not yet been implemented. Most significantly, public opinion has shifted over time. Surveys conducted in the United States in the period encompassing 1950 to 1991 asked the following question. Now I quote from the survey. From the surveys, when a person has a disease that cannot be cured, do you think doctors should be allowed by law to end the patient's life if the patient and his or her family requested it? That's the question. The percentage answering yes increased from 36% in 1950 to 63% in 1991. Most of the change came before 1973, with 53% answering yes in 1973. This shift in American public opinion paralleled changes in attitudes about religious practices, sexual morals, divorce, and abortion, mainly between 1965 and 1975, and there are books that have done these analyses, correctly or incorrectly. What we do know is that Americans are more inclined now than in the past to favor the abolition of present legal prohibitions of physician suicide. What we do not know is how extensive or how fixed such opinions are. That we don't know. The voting record of 3 states, Washington, California, and Oregon, suggests a fairly even split in the numbers of opponents and proponents of legalized physician-assisted suicide, at least in those 3 states. Poll data suggest a trend favorable to proponents, at least for now. To enter into the debate over assisted suicide, I contend that it is vital to understand the kind of thinking that fuels such an apparent trend. So, now to our second set of considerations. Threatening humanity's shared morality. A sectarian version of Mill in the debate over assisted suicide. A sectarian version of Mill. The debate over physician-assisted suicide is already being carried on in the American and Canadian courts. Although the votes of Washington State turned down the legalization of physician-assisted suicide, Chief Justice Rothstein, writing in a U.S. District Court in Washington State, declared that physician-assisted suicide is an individual's constitutional right. So that has been said in a court of law in Washington State. In turn, a California appellate court reversed this opinion. As noted earlier, Oregon's referendum approving the legalization of physician-assisted suicide is now in the courts. Canada's Supreme Court has upheld the constitutionality of Canada's laws against assisted suicide, but did so by a close 5-4 decision. So who's on the court is very critical at this juncture. We're into that again. In these court decisions, as well as many others, the streamlined version of Mill, fueling opinions that favor the legalization of physician-assisted suicide, is clearly evident and clearly stated. The consensus so far prevailing against this viewpoint is equally clearly evident and clearly stated. So we've got this debate right in the courts. And I'm focusing on the courts because no matter what happens in the legislatures, no matter what happens to the referenda, in this country it goes to the courts. That's unfortunate in many ways. It's not totally unfortunate, but in these cases, given what's in the courts, the streamlined version of Mill, it's very precarious and possibly very unfortunate. Now, an analysis of certain court cases will suffice to bring the heart of this debate into full view. To begin with, consider the opinions in the case of Elizabeth Bouvier. Now, Bouvier was a 28-year-old woman being cared for in one of Los Angeles County's facilities. She suffered from cerebral palsy, and her disease had progressed to the point where she required care and assistance for all of her physical needs and pain relief for arthritis. She also required supplemental nutrition in the form of a nasogastric tube. She petitioned to remove this tube. Removal of this tube was expected to lead to death by starvation. She couldn't swallow enough to survive. The patient was considered by all to be mentally competent and beyond that of a keen and lively mind, and she could live for quite a number of years. The tube was well tolerated physically. In the court's unanimous view, her mental and emotional feelings deserved respect. Quote, to petitioner, that's Bouvier, wrote the court, it is a dismal prospect to live with this hated and unwanted device attached. She has the right to have it removed immediately. End of quote. The patient's interests and desires represented the key ingredients to the decision. This decision was, the court wrote, a moral and philosophical decision that being a competent adult was hers alone. So if you're in the realm of philosophy and theology, it's yours alone. Furthermore, the court argued that Bouvier, quote, lying helplessly in bed, unable to care for herself, may consider her existence meaningless. Where did we hear an analysis of that? That's been brought out in this conference too, and there it is in the courts. She may consider her existence meaningless. She cannot be faulted for so doing. So anybody to the contrary is imposing, including what many of us think would be a caring physician and a caring nurse. In fact, they upbraided the medical personnel for hustling for her life. It's right in the decision. They scold them for trying to preserve her life. So far, all three judges agree. By the way, I'm not coming on the merits of this decision, right? And they are making use of Mill's calculus to paint a gloomy picture of Bouvier's life and its prospects, and to decide what is right for her to do. Also, like Mill, there is no natural, continuous desire to preserve one's life as in Hobbes and Locke, on which the Declaration of Independence is based in its concept of rights, with an assumption of a continuous desire to preserve your life. That's not in this court. Life may not retain its meaningfulness when abilities are lost and or pain enters the picture. And the court is agreeing with Mill that, quote, over himself, over his own body and mind, the individual is sovereign. The court is agreeing with that. But the court splits when it comes to interpreting what Bouvier wishes. And this is ironic. And what wishes of hers are to be free from government interference. Two of the three judges, this is an appellate court, two of the three judges contend that Bouvier does not wish to commit suicide, but only wishes to be free of her nasogastric tube. Judge Compton, however, when I say I wasn't judging the merits, you see, I mean, you could consider this, because she can live for a long time, question of suicide. But I don't want to get into that in the Bouvier case. That takes us, that becomes then a paper on the Bouvier case, which this is not. So they're saying, the two of them, she wishes to be free of the nasogastric tube. Judge Compton, however, in her concurring opinion, states unequivocally that Bouvier has made, quote, a conscious and informed choice that she prefers death to continued existence in her helpless and to her, that is to Bouvier, intolerable condition. She has an absolute right, there it is again, to effectuate that decision. Judge Compton found her death, Bouvier's death by self-starvation, inhumane, and maintained that, and I quote again, the right to die is an integral part of our right to control our own destinies so long as the rights of others are not affected. That right should, in my opinion, include the ability to enlist assistance from others, including the medical profession, in making death as painless and quick as possible. End of quote. Judge Compton was convinced that Bouvier wished to commit suicide. Accommodating her, in Judge Compton's view, should not trouble the medical profession because it has already abandoned the Hippocratic oath in the matter of abortion. She says that forth explicitly. According to Judge Compton, if there is ever a time, and I'm quoting, when we ought to get the government off our backs, it is when we face death either by choice or otherwise. End of quote. So, Judge Compton has incorporated still another element of Mill's thought, namely that, and I quote from Mill, the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. He cannot rightfully be compelled to do or forbear because it will be better for him to do so, because it will make him happier, because in the opinion of others to do so would be wise or even right. End of quote. You saw that last night. To justify legalizing a physician-assisted suicide, she called the law, out of date. Compton first calculates the disutility of Bouvia's life in her circumstances, and as in the Benthamite and Millian calculus, saw her pain and suffering as evils. Don't forget in this philosophy that evil is pain. Pain is evil. Suffering is evil, because it's not pleasure. Pleasure is good. Rightness of actions are judged here that way. So pain is by definition an evil, and the right act should be determined by wiping out this evil. Take this stuff seriously. This is behind fueling our public opinion and what is said in our courts. So that's her first premise, the disutility of Bouvia's life in her circumstances. Secondly, she asserts the sovereignty of individuals over their own minds and bodies. That's very familiar to us, straight out of Mill's quote. And three, prevents the state from interfering in harms or wrongs done by individuals wishing to do these harms or wrongs to themselves only. And you see, that's one of the places where the debate is enjoined. What's a harm to others? These three elements lifted from Mill's view of liberty are also found in other explicit defenses of a constitutional right to physician-assisted suicide, such as the one I mentioned by Judge Rothstein in Washington State, and in dissenting opinions by Judge Wright of California in the Ninth Circuit Court of Appeals, the decision that reversed Rothstein. There was a dissenting opinion exactly fueled by this same philosophy. And Judge McLaughlin of the Canadian Supreme Court echoed these very same arguments explicitly in her decision, explicitly in Wright's dissent, and in Rothstein's decision. It's all in there. I'm not reading it in, I'm reading it out. Now, why call these formulations a streamlined version of Mill? And here again is the inattention to history. History isn't counting here. Because in Mill's thought regarding justice as the name for stringent moral rules and the basis of human rights, he regards stringent moral rules, which are enforceable, as essentials of human well-being, as those that forbid human beings from hurting one another, and those which make, quote, safe for us the very groundwork of our existence. That's in Mill. But it's not in the essay on liberty, it's in the essay on utilitarianism. Most of my students have read the essay on liberty. They haven't read Calvin. I once had a show of hands. The only person that had read Calvin, over 100 students, was from a Catholic parochial school. Yeah. And all the others had never read anything. But practically everyone had read Mill's essay on liberty, from which my quotations came, before these that I'm now quoting. It says these social rules are the main element in determining the social feelings of mankind. So for Mill, nothing less. If you undermine these moral rules, nothing less than the main element in determining the social feelings of mankind and the groundwork of our existence are involved. But this is a streamlined version of Mill. All of that is dropped. I've never seen any of that in a court of law around this issue. So I wanted to say that in fairness to Mill. Those judges who articulate the streamlined version of Mill do not discuss this aspect of Mill's thought, do not consider the possibility that harm to both oneself and others may consist of laws that undermine or unduly weaken the essentials of human well-being. This neglected portion of Mill's thinking is not found in his essay on liberty, as I've said, but in his essay on utilitarianism. Now, Mary Ann Glendon, a professor of law at Harvard, has noted, and I quote from her book, Rights Talk. You ought to read that, Rights Talk. That's the title of the book, Rights Talk. To a greater degree than any other, the American legal system has accepted Mill's version of individual liberty, including its relative inattention to the problem of what may constitute, quote, harms to others. That's a quote within a quote. And concern with types of harm that may not be direct and immediate. These are neglected. Indeed, we took Mill's ideas a step further than he did, for when Mill's ideas, she can say we, she's a lawyer, for when Mill's ideas about liberty of conduct were taken into American constitutional law, they underwent a sea change. His stern sense of responsibility to family and country and his decided rejection, note this, of any notion that all lifestyles were equally worthy of respect, largely dropped out of sight. So we do indeed have a very special philosophy that we're struggling with and is represented all too well in the courts. Over against Compton's narrow understanding of what constitutes harm to self and others, the majority of the court in Bouvier case upheld California's ban on assisted suicide. Now that's an interesting thing, because even though they were quite Millian, they did uphold the ban against assisted suicide. And what did they appeal to? They appealed to a previous court decision in Ray Joseph, to the sanctity of life in this same Bouvier decision. Those who decided it wasn't suicide appealed to the sanctity of life to say, we are not overturning the laws against assisted suicide. We just want her to be rid of that nasal gastrotube if she wants to. Like many other courts across America, they distinguished refusal of treatment from suicide. The irony in the Bouvier case is that while seeking to carry out Bouvier's wishes, neither the majority nor Compton correctly characterized her wishes in 1986. This is when they were characterizing her wishes. Bouvier did not refuse the nourishment she needed to live. There's an article in 1992 in a law newsletter that verifies her continued wish to live 6 years later. I got this in 1992. I want to see if she's still going. I haven't traced it down yet, but 6 years later, she's telling a reporter for this law newsletter, I'll die when I want to. But look at what the court had said about her wishes. Look what the lawyer who represented her said about her wishes. Do you know who that lawyer was? He was the first counsel to the Hemlock Society, and he has committed suicide. That's what prompted this 1992 article to talk about the suicide of this lawyer. The Bouvier court, not, by the way, in the context of terminal illness, the Bouvier court did not work with the Hobbesian and Lockean view that there is a natural striving to preserve one's own life. They also lost sight of the natural shared morality of all humanity that undergirds the sanctity of life. This shared morality is known to Christians as the law written on the heart. Bouvier and her caregivers remained under its influence. They naturally, and she naturally, pursued her life. Their natural God-given inhibitions against killing oneself and others and the natural God-given proclivities to nurture life were sufficiently strong to cope with and relieve a very difficult set of life-threatening and painful circumstances. It is this view of morality that belongs to the consensus and sustains individuals and communities, and not the special sectarian theological anthropology of Mill that has entered the thinking and opinions of American courts and has fueled a more permissive attitude toward physician-assisted suicide. Now, one of the most explicit affirmations of this consensus is found in the majority opinion of the Canadian Supreme Court in 1993, upholding the constitutionality of the Canadian law against assisted suicide. The law was being challenged by Sue Rodriguez, suffering from Lou Gehrig's disease and seeking a right to physicians-assisted suicide. In her dissenting opinion, Judge McLaughlin had invoked the streamlined version of Mill already sketched above. Justice Sopinka, S-O-P-I-N-K-A, Sopinka, directly repudiated the notion that justice amounts to individual-based principles of privacy, writing that, quote, respect for human dignity and autonomy, McLaughlin's sole criteria for justice, is but one component of justice, end of quote. Upon which, I'm sorry, not end of quote, but one component of justice upon which our society is based. Justice Sopinka portrayed justice as embodying the requisites of community, ironically citing a former majority decision of Judge McLaughlin to that effect. Here's that inconsistency again. When it comes to these matters, like a physician-assisted suicide, the right over your own body, you throw out all the other things you believe, and McLaughlin does it too in the Canadian court. Because she had written, quote, the principles of fundamental justice are concerned not only with the interest of the person who claims his liberty has been limited, but with the protection of society. She herself had written that in court, in an opinion. Thus, determining the content of justice in the context of assisted suicide required reference to the state's, argued Sopinka, quote, to the state's interest in protecting the vulnerable and societal beliefs which are said to be represented by the prohibition. You have to protect the societal beliefs that underlie this prohibition, says Sopinka. And then he goes on to talk about the purpose of the law against assisted suicide is grounded in the state interest in protecting life and reflects the policy of the state that human life should not be depreciated by allowing life to be taken. This policy finds expression in the provisions of our criminal code which prohibit murder and other violent acts against others, notwithstanding the consent of the victim. Notwithstanding the consent of the victims. It's still murder even if they consent. This is not only a policy of the state, however, but is part of our fundamental conception of the sanctity of human life. And by the way, he believes it has a secular meaning and a secular use. Preservation of human life is acknowledged to be a fundamental value of our society. In fact, a number of the justices, as this went through the court, says it's a fundamental value of any society. Judge Sopinka then underscored this conception of justice, which expresses the moral requisites of community, by outlining the history of suicide provisions, common law views of medical protection for the terminally ill, and legislation in other countries, which included the United States. Finally, Judge Sopinka cut through the controversial distinctions between withdrawal of treatment and assisted suicide with the conclusion that, and I quote again, to the extent there is a consensus, here it is, right in the court, it is that human life must be respected, and we must be careful not to undermine the institutions that protect it. Notice the expanded notion of what is a harm, right? In upholding the respect for life, the laws against assisted suicide may discourage those who consider that life is unbearable at a particular moment, or who perceive themselves to be a burden upon others, may discourage those from committing suicide. End of quote. So here, justice reaches out to those who see themselves as a burden and seeks to prove them wrong, and says that they see the respect for life as a moral responsibility of the Canadian state and community, and states and communities generally. Now consider briefly also the decision of California's Ninth Circuit Court of Appeals asserting the constitutionality of Washington State's law against assisted suicide. Like the Canadian Supreme Court, the majority opinion written by Judge Noonan is firmly grounded in the legislative and constitutional history which he which he invokes. Pellegrino was right on the mark. Pellegrino could have written these opinions. He could have. You'll recognize it in a minute. Quote, by the way, Judge Noonan wrote this. Judge Noonan is known as a Roman Catholic scholar. He's now a judge on the Ninth Circuit Court of Appeals in California. He never uses the term sacredness of life. In the 205 years of our existence, no constitutional right to aid in killing oneself has ever been asserted and upheld by a court of final jurisdiction. A federal court should not invent a constitutional right unknown to the past and antithetical to the defense of human life that has been a chief responsibility of our constitutional government, end of quote. And the court takes aim against the streamlined version of Mill that led Judge Rothstein to ignore the harms to others the state seeks to protect through its laws against assisted suicide. And I just list these quickly. He lists the following state interests. 1, the state has an interest in not having physicians in the role of killers of their patients. 2, an interest in not subjecting the elderly and even the not elderly but infirm to psychological pressure to consent to their own deaths. 3, an interest in protecting the poor and minorities from exploitation. 4, an interest in protecting all of the handicapped from societal indifference and apathy. 5, an interest in preventing abuse similar to what has occurred in the Netherlands, and I won't repeat what has occurred in the Netherlands. Now, Judge Noonan also faulted Judge Rothstein for failing to distinguish between actions taking life and actions by which life is not supported or ceases to be supported. There is a right to be let alone and to do so by refusing treatment, but Judge Noonan argued the claim to a right to have someone licensed by the state bring about your death is no longer seeking to end, quote, unwanted medical attention. You are asking for the right to have a second person collaborate in your death and to protect all of the interests enumerated above. The statute, the law against assisted suicide, rightly and reasonably draws the line. Well, now quickly, briefly, what do Christians have to contribute in this policy debate over physician suicide? How should Christians conceptualize their role? And I'll be very brief. To begin with, Christian beliefs support the long-standing consensus that you also see in the courts that puts a floor under the laws against assisted suicide. Christians affirm the natural and divine basis of laws that protect innocent human life. The philosophies of Hobbes and Locke cited in American courts do also. It is only what can be viewed as a sectarian, streamlined version of Mill that undercuts these affirmations of the natural propensity to preserve one's life. And we could add the life of others. But Hobbes, Locke, and Mill all conspire to deny the natural basis of our responsibilities to one another. The Christian belief that the moral law is written on our hearts is a belief in the natural basis of our inhibitions against killing and of our propensities to procreate and nurture life. This belief is needed because it is realistic and true. And it is necessary to instruct and remind people of their moral responsibilities through law. And that was Calvin. And to curb the evil desires of those who ignore or violate the moral law. And that was Calvin too. But it's also scriptural. Christians should not view themselves, nor should they be viewed by others, as seeking to impose their particular morality on society when they defend laws against assisted suicide. Rather, Christians should be joined by the whole society in defending natural responsibilities to refrain from killing and nurture life. These responsibilities are among the moral requisites of community. No community can come to be and sustain itself if the natural inhibitions against killing and the proclivities to procreate and nurture are weakened. And that has happened in the Netherlands, because the inhibitions have weakened enough that you don't have to ask a patient whether they still favor life in their conditions. So much is the inhibition against killing weakened. If it's strong, you want to know. So, given all the killing going on in the world, the inhibitions against it need all the encouragement of instruction and law to faith that faithfully, biblically true Christians have to offer.